pioneered digital analytics and data protection regulation in Europe. And today, especially my pleasure, she will be talking about a hot topic, artificial intelligence, as the new player in town and here to stay. And it's urgently needed to be embedded into a framework of compliance and legislative enforcement. And that's something that we will learn something about today. So thank you very much, Aurelie, for being here today. And yeah, you can go ahead now.
Super. Well, thank you so much, Peter, for the nice introduction, and lovely being here. Apparently, I have 45 minutes to walk you through this general idea of whether the upcoming AI Act in Europe is an evolution or actually a revolution. And I will try to make my point as clear as possible within these 45 minutes, maybe a bit less, sharing some knowledge around, well, what you need to think about and where we might be going in terms of obligations. So just briefly about me, this is kind of a recap of what I've been doing for the last, I think, 20 or 25 years. I was interested in the internet and certainly digital analytics, web analytics called at that time, because there was so much data. As I always tell the lawyers, I'm a recovering dataholic. I love data. But I also realized pretty fast that there might be issues and potentially harms for our societies as the use of big data and other tools was increasing with time. So I started listening to the lawyers, and since then I have worked on my own consultancy here in Spain, where I'm currently based. I'm Dutch, French speaking, so my heart is terribly European. And my background, I'm not a lawyer, my background lies in econometrics. So everything that has to do with statistics, which seems to be coming back with AI, so I'm really happy about that. But I also worry about probabilities, false positives, and false negatives. So as I mentioned before, my background was in statistics. It still is, and through the years and the decades, I've seen this being called big data, machine learning, and today we basically call this artificial intelligence. And together with that, well, legislation has also evolved. You might have heard about this piece of legislation out of the European Economic Area, but also applying still to the UK, called the GDPR. You might have been annoyed by these cookie requirements under e-privacy, which is a specific law that also calls on the GDPR for certain issues like consent. And you might have heard also that on the other side of the Atlantic, things are evolving with certainly in California, but also about a dozen US states that are starting to talk about the possibility to opt out for sharing or selling of personal information. So the journey has been long, but something I certainly wanted to talk about that happened, well, in my corner of the world not very long ago, was an issue about young children, well, not so young, teenagers, let's say, using information of their classmates and then uploading a tool that created Gen AI and that created videos that were potentially not of their age, and then sharing this. And this, when this came out back in September of this year, so this is really recent, created kind of a turmoil, certainly here in Spain. Also because Spain is the biggest finer when it comes to data protection and GDPR fines coming out of a supervisory authority. Not always the highest fines, but certainly a number of fines being issued. The Agencia de Protección de los Datos here in Spain is the one that has always been like the locomotive. And everybody always forgets about it because we hear about the Germans and we hear about the big fines that come out of Ireland potentially. But certainly Spain has a certain role to play when it comes to defining and trying to understand and support best practices for uses of data. So this issue happened about over a month ago, and more recently also on a more personal level, because I draw from experience from my personal life as well. My daughter shared some data from her schoolmates taken within the school ground premises and was grounded for it. And we had long discussions about this as well. But it's interesting to note that, for example, here in Spain, there are certain bans in certain what's called comunidades. So Madrid, for example, is one of these communities here in Spain where children are actually not allowed to bring phones to school. And so when I saw this news about minors creating videos that were of bad taste and sharing this, we started also thinking together with my children about what this meant in terms of responsibilities. And this is something I wanted to talk about as well, is that the entire processing of personal data for this specific issue that took place in Spain evolved minors, minors that were using tools, so they were processing the data, and minors of which the data was being processed. And that these pictures were taken close or within the premises of the school, and clearly no consent was asked from the people whose pictures was taken. So in there, we can start thinking about who is actually responsible for this. Is this a lack of education by the parents? Is the school responsible for this? Is the tool that allowed this generative AI videos to be created, is it maybe where the tool could be downloaded, the gatekeepers? Is it the kids themselves? Should we like throw our hands up in the air and say, oh my God, education is really terrible and this is going to be a big problem for our societies moving forward? But this is an example to show you that when we talk about data protection issues, privacy issues, and certainly harm for artificial intelligence, the question needs to be boiled down to what does this mean and who is involved in this data processing operation, and also thinking about what this means in terms of gatekeeping or rules. Should we regulate? It's coming, so we are going to regulate because it also makes better products when they are regulated. After all, there's a reason why we have seat belts in our cars. It's to actually save lives. But really thinking about beyond this idea of, oh my God, AI is bad, is what are we talking exactly about? And so context really matters. And having these conversations about what am I talking about exactly within this data processing operation, who is responsible, is going to be the entire challenge, I think, for artificial intelligence. So we need to define these guardrails, these swim lanes, these seat belts, because in the end, good AI is certainly regulated AI. We hear often about these conversations that innovation might be limited because of obligations. And it's I think a false dichotomy. I think things evolve way better when we have this idea of what are the guardrails, or what are the swim lanes. And there are examples of this that already existed many years ago. This is, for example, more of a joke than anything else, but seat belts were not imposed by legislation. Seat belts were created by Volvo to say, well, we've done crash tests and we realized that it's a good idea to have a seatbelt. And therefore, it actually came after Volvo freed up that patent and put it out there. It became part of legislation for cars in Europe. So it's not always this idea of legislation bad and we're not going to evolve and we're all going back to our caves and just, hunt for food and live by the fire. but it's about working together to make sure that harm to individuals who will be impacted by automated decision making or artificial intelligence understand and can and trust also the technology that's being used. So when we talk about these guardrails, what are we talking about exactly? You know, aren't these Europeans terribly annoying with their ideas of legislation and GDPR, and it's such a waste of time? Well, I wanted to walk you through a bit where all this comes from, the foundations of what the AI Act is going to be about, so that you also understand that this didn't fall out of the sky, and neither did actually the GDPR. So a document I share a lot with certainly data engineers is the Charter of Fundamental Rights of the European Union. And where basically when we talk about AI, we're certainly talking about Article 1, which is about dignity, this idea that you can choose your life. Serendipity is, for example, one of my favorite words in English, and that these choices should be respected and should be protected. And certainly when we talk more and more about automation for example, jobs, or whether your premium for insurance is going to go up because you smoke or because your children want to get into a certain university, but they were they were punished because they shared pictures many years ago. Well, this is basically what we're talking about, making sure that these decisions that we take in life are not going to drive the next 100 years of our lives or more, as also the length of our lives is continuing, and deleting data is not the easiest of endeavors that I've seen so far. So Charter of Fundamental Rights, 53 articles, easy to read, easy to share. Certainly when companies are starting to talk about ethics and values, the Charter is really a good basis. And together with that, there's another document that I don't really recommend that you read. It's called the Treaty of Functioning of the European Union. It's like how all this is going to be decided and works, and who has which powers and things like that. But what I did want to point out is that these two documents together creates basically a very solid structure to make sure that the laws that we decide today, whether it's the GDPR, whether it's potentially an e-privacy regulation, are rather flexible, but will continue to be built. And I typically compare this, as I live in Spain, you might have noticed, I typically compare this to La Sagrada Familia in Barcelona, which is a cathedral that was designed by Gaudi and is eternally under construction. And I think as our values evolve through time, certain things were acceptable 20 years ago and are not as there to support our vision of our societies, and that the law itself, while we can consider it rather dusty, is actually also a living instrument that is eternally under construction. So based on this, I just wanted to highlight that Brussels has been horribly creative when it comes to new acts, which are actually regulations. It's just another name, another fancy name the Commission has decided to use. But different legislations have been certainly enforced since the GDPR. Obviously, e-privacy regulation is still in discussion, so we're still with the directive, with different countries having kind of different rules, and it's still a bit complicated when it comes to cookies or information on devices, which also include IoT. But there's other stuff that's actually coming, and one of these things is certainly the AI Act. So when it comes to the AI Act, where are we? We are what's called in trilogue mode. So this is being discussed between the Council, the Parliament, and the Commission in Europe. And we are currently under the Spanish presidency. A lot of references to Spain here. I'm really sorry about that. But I expect the ink to be dry on the AI Act by the end of the year, if not in the spring of 2024. It will take a bit of time before enforcement starts, but it means that basically we're building on top of the GDPR to start thinking about obligations, certainly around transparency and safety for the uses of AI or automated decision makings. Something else also that's the council actually started many years ago. You know, the GDPR, it got started to be enforced in 2018. Prior to that, we had the Data Protection Directive of 1995, which was slightly less enforced, but there haven't been that many changes between actually the directive and the regulation. But even before 1995, the Council started talking about this idea of international data transfers between different countries, and also this idea of when you use automated decision making that impact people's lives, it would be a good idea to define certain guardrails to make sure our societies go in the right direction. And that is actually called Convention 108. Not a lot of people talk about this, but this is really this idea of trying to support international collaboration in defining the similar structures between the different continents, and not just Europe doing its thing by itself. So I'm sharing here the link as well. It comes up from time to time. The convention has been there. I think over 50 countries worldwide have signed this, while more than 170 countries now have privacy laws. So it's interesting to follow and also get ideas from when you think about what compliance might mean or what ethics might mean for your data processing operations. You might think also that the United States is like a country who doesn't care about privacy. This is debatable. It's true that we're still waiting for a federal privacy law. But to be honest, since certainly 1973, the United States have been discussing this idea of fair information practice principles, also called the FIPS. And actually from there, a lot of the principles within the GDPR, but also, for example, the LGPD in Brazil, API in Japan, and other countries have been influenced by these US-based FIPS. So here again, I'm sharing information. It's about a video of about 7 minutes by the FTC, which is also interesting to see, to try to understand where, you know, the pillars of all these privacy foundation come from, and how we can move forward using AI and data to support decision making. How does this then link between the charter that I mentioned in the beginning and then the legislations that you actually know, GDPR and e-privacy? Well, it's like these Russian dolls that go inside one another's. Article 8 addresses the GDPR, while Article 7 addresses e-privacy. So there's like a very logical construct starting from the charter towards different types of legislation. And that will continue to evolve from a legislative perspective, but also from an enforcement perspective. And when the parties don't agree, well, everybody goes to court, and we all wait to see what happens at the European Court of Justice or the Court for Human Rights in The Hague. It depends a bit on the situation. But if we compare from a global perspective, how basically the two main continents we typically talk about, obviously there's other things going on. India is starting to think about passing a privacy law once again. But if we think about it from a very high level perspective, so taking really a helicopter view from the Sagrada Familia, well, basically what's happening is the United States mainly thinks about data as something that supports businesses, that should support growth, and where the highest level of rights for individuals is typically seated within this idea that you can opt out. If you don't want your data to be shared or sold, you can signal this, and hence your data will not be shared or sold. In comparison to this, Europe talks about this idea that, well, companies who want to use data should be accountable. The responsibility lies with them. And therefore, The threshold to use data is one of opt-in, and where basically companies need to decide how and which lawful basis they're going to use for processing personal data. Interestingly, both sides are starting to are starting to go beyond PII, personally identifiable information, as they both embrace this idea of big data, that different bits of information can make up a profile of an individual. And therefore, think also in terms of the fact that it's broader than it actually used to be. So the application of these laws are actually broader than it used to be. The big difference remains certainly when we're talking about the third category of actors when processing personal data in Europe or personal information in these US states, is that the US actually recognizes a market for personal information. They recognize the fact that data brokers exist, whereas the GDPR talks about joint controllership. So the fact that it's possible that you can share data between different entities, but then two entities are responsible if they want to share that information, and you need a lawful basis to do that. Building on top of the GDPR, there's not just this idea of privacy. There's increasingly also this idea of, well, it's a matter of competition, antitrust. You might have realized through the years that there's a lot of power for certain platforms, and different tools within the legislative toolbox are trying to address this as well. So, for example, the Digital Markets Act is addressing the obligations of gatekeepers, how transparent they should be with the data that they're actually using. The other piece of legislation that was rolled out rather recently as well is the Digital Services Act. Sorry. The Digital Services Act, which actually talks about this idea of fake news and the fact that content that is potentially not verified is being shared through very large online platforms. And then the last piece of legislation that we're actually talking about here is the AI Act, which specifically actually falls under this idea, like we talked about the seatbelts, of trust and safety. What are we seeing today in the European Economic Area? Well, under the GDPR, there are certain obligations. So as I mentioned, the scope of personal data is broader than it's under this idea of PII. We need to abide by principles and a lawful basis, which is not only consent. And then there are certain roles, data controllers, data processors, and joint controllers who each have their own obligation. E-privacy is kind of a subset of the GDPR, so it's important to understand that the two are actually different. And e-privacy is typically the one we talk about when we talk about cookies. But we're increasingly also going to talk about this idea of server-to-server connections, so the fact that cookies are disappearing slowly but surely. What's important to note, and this is often forgotten, is that e-privacy has actually a wider material scope. It talks of any information on a device, but it's actually narrower in terms of situation. So it's really about terminal equipment and seeing if something is being read, yes or no, on that device. The big difference also with the GDPR is that it just has one lawful basis, which is consent, and this is also why we're seeing all these consent banners. Note also that consent banners have been built, I think, by the industry to basically make sure that they continue their business. I'm not sure each business that has a digital property actually needs a consent banner, but that is very contextualized. It really depends on each business and how they use digital tools and analytics. A slight word on the DSA. I'm not sure if this is loading correctly, but I just wanted to mention that the Digital Services Act also has its like penchant, certainly in the United States, called Section 230, where basically in the United States, it's considered that platforms are not responsible for the content being uploaded. We'll have to see how this evolves moving forward. Some data for those who, like me, are dataholics. There's an interesting website from the Commission about all these takedown requests by these different large online platforms. The spike here is Google Shopping, by the way, that happened like a couple of weeks ago. But what we're seeing certainly today is that the market is requiring, and I think individuals as well, but certainly legislators, requiring more transparency when it comes to uses of data. And I think that is going to be the challenge moving forward. On the DMA, we're seeing the same thing. Anybody that's been working on iOS 17 privacy nutrition labels might have worked on this as well. So starting to define what kind of data is being picked up by the SDKs and the kits. I'm sharing here also the link so that you can find out more. It doesn't, however, mean when certain actors within the industry are pushing for certain solutions. I'm specifically talking about Apple's app tracking transparency, that this actually aligns with legislation. We shouldn't forget that each actor within the data ecosystem hedges for their own risk and their own obligations. How they then tell a story to the market is something else. But it's always important to take a look at the different angles of data processing operations to make sure we understand who is responsible for what and what the consequences are today and in the future, which is not always easy. Yeah? So it's a continuous movement and challenge of collaboration between different departments within companies. The link between the GDPR and the AI Act actually already exists. It's enshrined within Article 22 of the GDPR around automated decision making, including profiling. And so this idea that there is a right for European residents to say, I want to object to this decision making that is done by machines. And we haven't seen a lot of movement on this, but this is certainly increasing as there's more and more talk about AI. Personally, I consider AI to be a subset or a generalization more of automated decision making. Potentially, there are certain new aspects to it, but it often goes back to this idea of what are you doing with the data? What are you predicting? What are potentially the false positives and the false negatives within these predictions? And what could potentially be the harm to individuals if you impose these predictions? Why am I telling you this about Article 22? Well, enforcement has actually already begun. So there were already a couple of court cases where companies had to explain to data subjects why, for example, a credit had been refused. And in this very specific case related to, I think, a bank in Berlin, if I remember correctly, somebody complains when a credit was refused, and the bank had to explain how they got to that conclusion. Unfortunately, they were not sitting on that information, so didn't give that right to the individual of explainability, and hence they were fined 300,000 euros. Are these fines actually the real risk? Well, I would argue not. And this is actually not totally new either, even though it has evolved with the GDPR. Supervisory authorities are a bit like an iceberg, where the fines are the tip of the iceberg, but underneath there's a lot of power as well. And so I'm listing here, they are defined within Article 52 of the GDPR, but I'm listing here all these powers that they have and that they have been exercising slowly but surely. I think generally speaking, we have this idea that, well, you know, there was enforcement of the GDPR, but it's kind of dying down. Today, and I think this is very extremely recent, the European Data Protection Board, pushed by the Norwegian Supervisory Authority, is asking for a ban for behavioral advertising for the use of Facebook and Instagram. So the consequences of that, which opened up an entire new Pandora's box, is that now users of Facebook and Instagram within the European Economic Area are faced with a choice, either to pay around 13 euros a month for the use of Facebook without ads, or to continue as they have been using Facebook and Instagram until now. It's an interesting conundrum, I think, on different levels, because suddenly we're also starting to talk about paying with your data and whether privacy, which is a fundamental right in Europe, is for sale, yes or no. I think the conversations are still going on, but we're seeing more and more of this idea of, well, if you want us to respect privacy, you'll have to pay for it. Whether this is lawful or not, we'll have to see how this basically pans out. So the question I often get also, as I act as independent and external DPO for a lot of customers on a global level, is what am I responsible as a DPO? I look at, well, basically what is promised to data subjects. So we are responsible in front of data subjects. And these promises are made through either the privacy notice that you see when you accept terms and conditions, or maybe sometimes you actually read the cookie policies. But also, as this ecosystem is rather intricate, the fact that, well, between the data controller in front of the data subject, there's also data processors behind. And so these data processors need to make sure that they actually support, well, the promises made to the data subjects by the data controllers. So what we've been seeing certainly over the last 5 years is the fact that there's more granularity when it comes to the uses of data than before. There's more choices and options for users, which also makes it slightly more complicated to actually understand what you're agreeing to or not. But this is certainly something that will continue to evolve, this idea of granularity and also transparency and education in front of consumers and data subjects to understand how are their data is being used. How is this translated into AI? Well, in a nutshell, it becomes slightly more complicated because, well, basically you've got new actors that are coming to the table with models that you can just grab off the shelf and then input inside your own decision making. And so, while before it was already complicated to understand who was a data controller and who was a data processor, and there's still sometimes confusion about this, when it comes to AI, this actually becomes slightly more complicated in terms of responsibilities. And so this is, I think, the challenge that will certainly be in front of us to define, okay, what are these obligations? What are the roles played by the different entities involved in the use of AI? And who does what between the initial collection of the data, the creation of the models, but also imposing the decision of not receiving a credit or giving a credit by a bank to a user. So here, the Norwegian Consumer Association wrote an interesting document about this to start thinking about what this actually means and how we need to start thinking about the different actors. What we're hearing, obviously, from AI actors is, well, could you please regulate us? As a European, I'm like, you are regulated, so could you just do your job? And we are seeing this. OpenAI has certainly, and ChatGPT has more functionalities than it had 6 months ago, and has less functionalities that it will have in 6 months. So we'll see how this basically evolves. But when we get our feet back on the ground, we need to not forget, when it comes to even AI, that if it's processing personal data, it falls under the GDPR. So there are obligations either for prescriptive data or probabilistic data. And certainly if you act, sorry, as a data controller, you need to abide by the principles the lawful basis, but also the transparency. And if you act as a data processor, where you're basically acting upon the instructions of the data controller, you're going to be faced also with interesting challenges about which sub-processor you use. And if these sub-processors want to use AI, what does that actually mean? So I think, generally speaking, this idea of due diligence that the different actors had to play, whether it's in Europe or whether it's, for example, in California or other states, is going to increase. It's going to increase, and questions need to be asked, and more documentation will be needed to make sure that, well, risk is under control for companies, but also that harm for individuals is also safeguarded in the best way possible. It's a continuous journey to make sure we go in the right direction. Because risk for processing personal data or personal information is on the rise. And again, I would say this is not just Europe and the fines. This is certainly also the United States, where we're seeing more and more class actions around privacy. We're seeing people who understand that they can complain to supervisory authorities. There's more rulings coming out. And there's also certainly more transparency that are fueled by freedom of information rights being exercised, for example. So I think, generally speaking, more transparency also means potentially more risk, certainly for companies who want to jump on the AI bandwagon. What kind of harms are we talking about? This is an example. The example I shared earlier in this presentation was certainly about psychological harms for the young girls that were inside these videos that were created through Gen AI tools. Um, and I think we'll see more and more of discussions about potential harms, but it's important to be specific, not just financial harms, but to try to define what kind of safeguards we can put in place to basically make sure that these harms are mitigated as much as possible, just as risk under the GDPR has been mitigated as much as possible. And I think the best companies to basically embrace AI and make sure they do the right thing with respect to potential increase of risk for using personal data and AI systems is to continue the journey they've been on with the GDPR. So it's again this idea of it's eternally under construction, it's a cathedral, and it's not a checkbox exercise that you'll do just on potentially on annual basis, but something you need to continue thinking about. Transparency, as I mentioned, with customers is, I think, the way to go forward, certainly when we talk about trust and the fact that your customers will continue using your products and services because they have a trustworthy relationship with your company in the long term. AI will, I think, increasingly involve external auditing. I'm sharing examples also here of certain systems. And so I'm kind of seeing like the accountants and the auditors thinking about how they can support compliance obligations for companies using AI. While there are different roles within the analytics ecosystem, I think one of auditing and making sure that you are as compliant as possible is something that will certainly rise within the next couple of years. Who these actors will be, I'm not totally sure. Firms like PwC have audited systems like Facebook. It didn't turn out that well. So we'll have to see how we kind of evolve within this idea of recurring revisiting of data processing operations. The challenges, as I said, are, I think, dynamic. I think the way we do it today is still imperfect because there's still a lot of questions to try to understand how to best tackle this. One of the major issues I've certainly encountered over the last 5 to 7 years is one of deleting data. I think it's getting better. I think people are getting used to it now. But I think the next challenge that is today coming up is this idea of transparency. and potentially also these notions of harm. Fairness is one that is really preferred in the United States. Personally, as a European, I think there's more harms than just this idea of fairness, but we'll have to see how this translates into potentially supporting these auditing obligations through, for example, data protection impact assessments that are already part of the GDPR. There's going to be more people coming to the table also with AI. Why? Well, because there's also issues around copyright when it comes to uses of certain types of information for these different tools. And we'll also start talking more and more, I think, and certain actors within the analytics, digital analytics realm are already talking about this, is this idea of sustainability. So this is kind of going towards ethical uses of data and making sure that not only from a privacy perspective we are going in the right direction, but potentially also to make sure that we support our obligations as actors on a planet that needs some help to make sure we can continue living here. So as I mentioned, intellectual property challenges are being added to this idea of AI. Here are some examples of this. Discussions about what this means in terms of money. So I mentioned this idea of a marketplace for personal information in the United States. Here, we're also, when it comes to AI, talking about, well, what does it mean when certain art objects are being used and reused by Gen AI tools? How are these money flows actually going to work? So what are we seeing in conclusion? Well, we're going to use more data. There's no discussion about it. There's going to be more regulation. That's also rather clear. And the risk is increasing. So we'll have to see. What does this mean for companies? More granularity of controls, understanding which actors are part of the ecosystem, but also more transparency around these data processing operations, making sure that we explain who is responsible for what between the actors. And I can only hope, as I hear about the AI acts in Europe and executive orders in the United States, that there's going to be more global coordination. I'm also very well aware that due to concentrations of power, there's obviously also going to be more and more lobbying. So I think we have to use our critical judgment, try to understand what our companies need to move forward, but also try to make sure that we document as much as possible what we're actually doing. I always recommend a movie at the end, and I've been recommending Mike Nicholson's Gattaca for a long time because this was really the worry I had with respect to where our societies are going. So if you haven't seen the movie, I really recommend that you watch it. And if you've enjoyed it, well, the next one is also one by Mike Nichols, and it's about this idea of transparency and whether this is potentially also a new threat that might arise, is this idea of, well, maybe we're going to share too much information, which we already are, but aren't we also going to be sharing, not being able to live our lives according to our own rules, and that this idea of anonymity is not going to be possible anymore. So second recommendation, except for Gattaca, Anon is a good movie to watch. I know Thanksgiving is coming up soon, certainly for my US colleagues. So I would warmly recommend this to also start thinking about, okay, how far do we want to go in terms of transparency? I think this is what I wanted to share. Thank you so much.
Great. Thank you very much, Aurelie, for that great and insightful talk. Also, especially for the worldwide privacy regulation, we see some similarities to the talk that we heard this morning by Max Schrems, who also stressed that island solutions are just a good try, but in the end, ultimately, we will need something which is worldwide because the internet spans worldwide. But also that's very complex to achieve, probably. But that's an idea that you both have in common, definitely.
Yeah.
There are a few questions. I also have a few questions. Perhaps we start with my questions.
Please do.
um, we see a lot of new AI. So at X or Twitter, we see nearly a new AI tool on a daily basis. So do you think that AI development will ultimately be regulatable when the development stays like this, at least, or will the development have to be stopped at some time, and so that we pivot and on how we proceed with everything, because the inner workings of those AI tools, the neural networks and everything, strongly oppose the idea that of transparent decision making somehow, because also the developers in the end could not say how did the machine come to this conclusion or this decision. What do you think about that development on those tools?
Yeah, I've heard it often enough that it's unexplainable. And I would tend to turn this around and say, well, if it takes decisions on my life, doesn't that worry you that it's unexplainable? And so I'm not enough of an engineer to, how should I say, to agree with that. But I do have issues with this idea that we cannot explain how the decision was made. And you could also draw parallels. If, for example, you want to eat some foods and you know it's bad for you, wouldn't you want to understand why it's bad for you and where it actually comes from? So I do hope that we still have choices to walk away from actors and say, I don't want to use this. I don't think Twitter's going in the right direction in any case. But yeah, it's still this possibility of doing the best we can in terms of explainability. And this is the challenge that's in front of us. How far do we go in terms of explainability? I also think that certain tools will just not survive because there's no reason for them to exist. Google Glass comes to mind. It's being used in a very niche, for a very niche purpose, if I understand correctly. But we were supposed to all walk around with Google Glass today, which is not the case. So yeah, I don't think we will come to a time soon where everything will be documented and clearly explained before anything is launched, because as any privacy professional knows, we all run after product and engineering to say, hey, what are you guys doing and can we make sure this is okay? But thinking that decisions are going to be made about our lives in some very strange future, I don't want to abide by that. And so what I say is, let's work together to make sure we go in the right direction.
Sure, good answer. Thank you very much. We have another question from Ronan, who asked if, because the idea of regulating AI or regulating the results of AI may be connected to the input data, to the training data, or to the output data. For example, there was the example of the generative AI ChatGPT that did not want to be rude to anyone, or use inappropriate language until someone impersonated some kind of other person and somehow tricked that generative AI. He asks if it may be a solution to only train an AI with consented data. So before you throw in training data into an AI, might it be practicable, at least to consent on that? So if some editor or some photo that you're on, for example, you have to consent to be used as a training data, or do you think that's not practical?
I think this idea that anything is up for grabs through scraping because it's public information under US law is problematic, because this is very opt out logic. from the US, and it doesn't work under this idea of opt-in for the GDPR. Um, I also believe that systems are capable of keeping traces of lawful basis and purpose and things like that, but they don't today. So that's the reality. So best next thing is, let's talk about harm. Let's talk about the negative consequences of this and how we mitigate for this. While we start all to kind of mentalize about we need to follow these data flows and have a lawful basis and a purpose and things like that. As I always say, whether you predict I like strawberry yogurt or banana milkshake has no consequence on my life whatsoever. If you predict whether I'm suicidal, that's another story. So it's really about the end game, I think, the risk, and going back also to your question before is, I mentioned the ban for Facebook and Instagram that the European Data Protection Board decided recently, because we are starting to talk about bans. There are conversations about you cannot use artificial intelligence for certain use cases. Whether this is going to pass in the AI Act is another question, but starting to think about harms high risk strawberry milkshake or banana yogurts is, I think, a good exercise to have. That makes
Sure,
sense.
thank you very much. Yes, we have a last question. I think we are running out of time as well, so I will try to tell quickly. Have you already, to get the full circle back to the web analytics or digital analytics topic? Have you already seen some cases where the use of artificial intelligence with web analytics wasn't appropriate or even used?
Well, I think there are certain, how should I say, certain functionalities, features within certain tools that have a big market share, that are rather problematic, and are sold under a very strange name that doesn't align with what it's supposed to do. And so I would say this is manipulative from the part of that actor. So yes, I have. And we'll have to see how current enforcement is going to tackle this. Apparently, they're part of the DMA obligations, so it's going to be interesting to follow.
Absolutely. So, and perhaps just one question left, because we also want to get the full circle back to Matomo even. Ronan is asking probably a silly question. He tells by himself, I don't know, I didn't read it yet, but if data are anonymized within Matomo, can we play with AI within this data, within this anonymized data, with, for example, the GPT integration or something like that? What is your opinion on that?
So I would say, Roman, prove to me it's anonymous. That's the first conversation we need to have. I have a nice document of 10 steps where we could like go through a checkbox exercise to try to confirm the data is indeed anonymous. And then the next question is, what are you going to use it for? What's the potential harm of the creation of these models? I would also say that you'd have to look at your contracts and if you can actually use this. But yeah, the first bit for Ronan would be, talk to me about anonymous and what you mean by anonymous, and let's see if we agree.
Okay, perfect. Thank you very much, Aurelie. So, Ronan, I hope you listened well, and this was very insightful, and also great to know that also the law and legislative is a living organ, which is not always perfect, but always striving to, to be adjusted to the current environment. So that was very insightful. Thank you very much, Aurelie, for being with us.
Thank you, Peter. Have a nice day, and thank you for setting this up and for the invitation.
My pleasure. Thank you very much. Bye, Aurelie.
Bye.